Thank you, Mr. Chairman. Chief Tidwell, thank you for taking the time to be here. One of the concerns that we have, and I know you're well aware of this, out of the state of Colorado, we are a headwaters state. Most of our water obviously originates on federal land. Mm-hmm. We've got the complexity that water coming off perhaps a Forest Service land may flow through private land onto BLM land, maybe even back onto Forest Service land. So a very complex issue, and I know our state has always appreciated and in fact demands that the state law, 1876 when we were incorporated as with other western states, that water is a private property right. We have state law, we've got a priority-based system that we expect to be respected. And the concern I think I would like to bring up, given the groundwater directive that we're seeing out of the Forest Service, when we couple this with the EPA waters of the U.S., we're seeing effectively, in my opinion, the biggest water grab in American history in terms of our ability to be able to grow our communities, to be able to protect the interests of the state of Colorado, and I think we've got a pretty good track record of being able to manage that. What concerns me, Chief, and I'd like you to be able to speak to, is in the Forest Service manual, it states that your employees claim water rights for water used by permittees, contractors, and others to carry out activities related to multiple use objectives. This is in the manual. We now see the Forest Service Groundwater Management Directive, and it seems to me that this literally doubles down on the policy to be able to obtain water rights in the name of the United States. But at this current time, this is a massive groundwater management policy that you're trying to put forward. So given the scope of this overall policy combined with the directive to obtain water rights under applicable state law for groundwater and groundwater dependent service water needed by the Forest Service, doesn't this effectively give the Regional Forest Service staff and the agency approval to go after any water right arising off of Forest Service lands that they deem necessary to carry out the broad objectives of the manual?
This proposed internal directive does not infer anything into water rights, does not infringe on the state's responsibility, their authority to allocate water. What this is about is to just evaluate and monitor the effects of our actions on groundwater. And if there's an opportunity to mitigate adverse effects, then we have the responsibility to be able to pursue that with the surface occupancy where we do have the authority. When it comes to use, the multiple uses, for decades we've had a policy in place where the best assurance we could provide the public that multiple use would continue is that when water is required for that multiple use activity, the best assurance was to be able to hold that water for the public. And there's been questions, some of the policies that we've had in place going back to the mid-'80s, and that we've worked with, like with the ski areas, back in the 80s to put a term and condition on their permits in place that worked very well, had no adverse impact on any ski areas. In 2004, I personally worked with National Ski Area Association to modify that clause so that it would work for everyone. We thought we had it done. Then a few years later, we find that, once again, it wasn't in compliance with all state laws. So we sat down again to be able to modify that. And now we're to a point where we're proposing a way to just keep the water, tied to the use. And it's just to protect the public.
Does it kind of concern you, though, Chief, when we're pursuing these policies? There is a threat. And one thing you did not speak to is respect for the state laws. There's case history for this throughout the western United States. You weren't speaking to that, but when we're talking about ski area permits, there's nothing in your policy that protects actually the ski areas. You still speak in those broad general terms in terms of some of the agreement that's coming out, and that's why we'd introduced and passed through the House with bipartisan support the Protecting Our Water Rights Act.
Well, we without any question, we respect the state's authority on water rights. It's one of the reasons that we sat down to change the clause that we had in those permits. And when you think about protecting, a ski area, if water is necessary for a use, and without that water, that use can't occur. And the public, we authorize whether it's any activity on a national forest, it's for the benefit of the public. And so if the public can't benefit from that activity without having the water, we just feel that water should somehow be tied, to the use, and if at all possible, be available for future uses. So whether something happens with a ski area, whether it's no longer financially possible to operate, that's something we, of course, would sit down and work with them. But in cases where if there's a foreclosure, for instance, and the financial institute needs to dissolve all the assets, it eliminates the opportunity for the public to ever enjoy maybe skiing on that area again. So this is what we've worked very closely to find ways to work with our partners, our proponents of these activities, to find a way to provide the public assurances that when we permit an activity, that we want to be able to maintain that for as long as it's viably possible. And that has been our approach on water. On the groundwater, once again, it's no new authority. It's just a consistent approach so that we're a more predictable partner with our states, that we can be a better partner with the states, work with them, and have the information to be able to answer the questions when we get challenged as to what's the effect of groundwater Forest Service on your proposed activity. We have to be able to answer that. If not, especially based on the last couple of court cases, we're going to go back and have to redo the analysis.
But with respect, it is important to note that not one ski area has ever sold off its water. We had that conversation, and you agreed with us on that. And there is real concern from the farm and ranch community that we are now seeing the federal government not only trying to be able to control the water above, but now below the ground. And this is going to have a real impact, I believe, negatively, potentially on our community. So, yield back.
And Congressman, I'm not, to my knowledge, ever since we've had the water clause in our ski area permits going back to the mid-'80s, I'm not familiar of any situation where there's been a financial impact. And yes, I'm not aware of any ski areas selling off their water, but I also don't know that because of that clause, maybe it prevented it. It would be interesting to look at some of the foreclosures that maybe occurred, some of the bankruptcies that occurred over the years with ski areas to just see. But the point is that we've worked very closely with the ski areas, and we will continue to work with them to be able to find a way that we can provide the assurances to the public that that use will continue, versus being in a position that the day when the water is worth more, has more value than the operation of a ski area, that water would be sold off or used for a different purpose, then the public loses out. And at the end of a 40-year term permit, if the decision is for the ski area not to go forward, well, then that's a good time to have that discussion.
The gentleman's time has expired. And now recognize